Hello friends, welcome to the CEC-UGC live lecture. Dear friends, in this session today we would be discussing on grounds for refusal of trademarks registration. Dear friends, we would like to tell you all this is the topic under our series Trademarks and Copyrights. We believe that you might have seen our lectures on trademarks and copyrights which we have conducted recently, and we want you to please give your feedback constantly so that we could arrange for you lectures, and we would like to give you more and more content under the series. So dear friends, I would like to tell you all that for this discussion on grounds for refusal or for trademark registration, we have once again within our studios Mr. Ashwini Sewal. Mr. Ashwini Sewal is Assistant Professor in IP and Data Security Laws, Faculty of Law, University of Delhi. So dear friends, let's welcome our guest under whose able guidance we would be discussing this topic at large. So without wasting any time, I would like to welcome Mr. Ashwini Sewal. Welcome to
Thank you very much. Welcome viewers. See, we have been discussing a lot about trademark in last few of the lectures. Today I am going to cover some of the prohibitions relating to the refusal of registration of a trademark. In my previous 2-3 discourses, I have completed, dealt with some of the prohibitions for the refusal of registration of a trademark, which we call generally in legal parlance as absolute grounds for refusal of registration. And when it comes to absolute grounds for refusal of registration, under Trademarks Act 1999, that became operative in year 2003. Under section 9, you see there are some of the prohibitions which are called absolute grounds for refusal of registration. That provision is very exhaustively worded provision. Section 9 has got 3 subsections, and in each subsection it embraces some of the prohibitions which are the grounds for refusal of registration at the pre-registration stage. Well friends, in my last discourse I talked about the very first prohibition under subsection 1 of section 9, which had around 10 prohibitions. That is how we categorized it in our previous discourse, that there were around 10 prohibitions covered under section 9(1). To name quickly those 10 prohibitions to recall into your memory, you see we dealt with section 9(1), where we found that first prohibition that gets covered under section 9(1) is about distinctive character. I mean, any trademark which is devoid of distinctive character shall not be registered at all. Then if you go further with the reading of section 9(1), we understood that there are some descriptive marks negated by purview of section 9 to be given trademark registration. For example, if any mark which talks about the kind, quality, quantity, intended purpose, value, geographical origin of any goods or services, then in that case that kind of a descriptive mark cannot be given trademark registration as per section 9(1). If we go ahead with section 9(1), I recall that there are 2 more things that get covered under section 9(1) and its purview, wherein marks which are established as something which is established practice of a trade cannot be given a trademark registration. Any mark which have become customary in the current language cannot be given registration. So that is how we dealt with section 9(1), and we have seen section 9(1) in a very elaborate manner, where we dealt with some of the case studies pertaining to section 9(1). Well friends, in today's discourse, in relation to some more prohibitions of section 9, you see, I will be talking specifically on prohibitions covered under section 9 subsection 2. Section 9 subsection 2 posits some more prohibitions for registration, disqualifications for refusal of registration, some more prohibitions for refusal. Well friends, if we compare section 9(1) along with section 9(2), we find that section 9(2) is kind of very widely worded, and it provides kind of very exhaustive clause prohibiting the registration, or prohibitions are given in a very exhaustive and wide fashion to be availed by the trademark examiner or registrar at the time of refusing the registration for a trademark at a pre-grant or pre-registration stage. When the applicant files the application to the registrar, then registrar as per section 9 prohibitions scrutinizes the application, and under section 9 subsection 2 the prohibitions given are widely worded. Why I do say and use the word widely worded? Because you see, as compared with other prohibitions, say for example 9(1), or as compared with other prohibitions covered under section 11 exclusively, I mean those are relative grounds for refusal of registration, 9(2) prohibitions, friends, are very wide because they can be invoked for the public good and from the point of view of the trader. I mean these prohibitions covered under subsection 2 of 9 are for the benefit or advantage of public as well as of the trader, and can be invoked by the trademark registrar in any of the case, notwithstanding that the case is of similar goods or a case is of dissimilar goods, or say similar services or dissimilar services. These prohibitions are the prohibitions which are absolute in nature, can be applied absolutely if their requisites gets fulfilled, or say their ingredients gets fulfilled. Let us analyze threadbarely everything that has been written or given under subsection 2 of section 9, friends. If you see the language of section 9 2, it reads, a mark shall not be registered as a trademark if it is of such nature as to deceive the public or cause confusion. Well friends, 9(2)(a) says, if any mark which is causing deception or causing confusion, if the mark is of such a nature as to deceive the public or is to cause confusion. If you see the language of section 9(2)(a), it is vouched in such a fashion, indicating and signifying that it is for the public benefit as well as for the benefit of the trader. Even the word public is used, and the presence of the word public signifies that the interest of the public and protection to be awarded and given to the public has been taken care of while making or enacting this legislature or this particular provision of Trademarks Act 1999. What this 9(2)(a) says and covers in its sweep is, again I will say, is very wide. I mean there is nothing given over here apart from the single point that any trademark which is going to cause confusion or which is of such a nature as to deceive the public. I mean this deception or confusion can happen in any manner, it can happen in any way whatsoever. That has not been given as to in what sense or in what manner the deception has to take place. So the clause is silent about the possible deceptions, the possible confusions likely to take place, and there at this this absence kind of gives a leeway or a scope of discretion to the trademark registrar to be applied by him. That discretion applied by him decides actually as to what is going to cause confusion, as to what trademark is of such a nature which may lead to deception or may deceive the public. Well friends, there are few more things that I would like to talk specifically about 9(2)(a), but before jumping to the further elaboration and further decipheration of section 9(2)(a), I would first of like to see the next prohibitions covered under section 9(2) itself. Then in totality we will discuss one by one separately. If we go to 9(2)(b), friends, it says a mark shall not be registered as a trademark if it contains or comprises of any matter likely to hurt the religious susceptibilities of any class or section of the citizens of India. As apparent and as clear from the language of section 9(2)(b), one can make out as to when these kinds of prohibitions are to be obeyed. Especially you see the word religious susceptibilities and you see hurting the religious susceptibility is used here. So any mark which is going to hurt the religious susceptibility or which has the potential of hurting the religious susceptibility should not be registered as per this prohibition covered under 9(2)(b). When it comes to the interpretation of 9(2)(b), friends, I believe there is no as such a need of interpreting it, but I have certain case laws and case studies to make you understand as to when you see this prohibition provided under 9(2)(b) is to be invoked and can be invoked. Let's move ahead and see another prohibition covered under 9(2)(c), which reads that the trademark shall not be registered as a trademark if it comprises or contains scandalous or obscene matter. Friends, any mark which comprises or contains anything which is scandalous or obscene shall not be registered. This is the plain black written law and the language covered under 9(2)(c). Its interpretation has to be dealt by me separately in few minutes from onwards. Let us first of all complete 9(2)(b) and its prohibitions. The last prohibition provided under section 9(2) is in subclause D, and it reads, a mark shall not be registered as a trademark if its use is prohibited under the Emblems and Names Prevention of Improper Use Act of 1950. So kind of you see this is the entire language on screen in front of you. When you read this entire language of section 9(2), the very last prohibition covered under 9(2) in the form of anything which is prohibited to be used as a trademark under the Emblems and Names Act shall not be used. It is quite clear and plain. I mean, one can easily understand it. But the preceding three prohibitions on your screen under 9(2), that is A, B and C, they require little attention and further interpretation, especially 9(2)(a) viewers. When we see this 9(2)(a), you see it is a kind of a Pandora box. There are so many things that can get covered under 9(2)(a) because no specific rider has been attached. If you can see the screen, it is a plain disqualification or a prohibition covered under 9(2)(a), which says if anything is of such a nature which may deceive or cause confusion shall not be registered. Then 9(2)(b) is kind of little less complex in terms of interpretation. Similarly, 9(2)(c) is also little less complex in terms of its interpretation. Well, let us first of all start with 9(2)(a), friends. We will do the threadbare analysis of 9(2)(a), and we see there are two keywords given under 9(2)(a). The very first keyword or these two keywords, which to my understanding are the heart and soul of this 9(2)(a), are deception or confusion. What is the meaning of deception? What is the meaning of confusion? That has nowhere been provided under the Trademarks Act 1999. So we will go by the literal meaning, and when we don't get any clear idea from the literal meaning itself, then in that case we can rely upon the judicial interpretations wherein these two words, deception or confusion, are deciphered and interpreted. If we go further, then we find from the language of 9(2)(a) that this is widest of all prohibitions, as cited and told by me as well as reiterated by me, that this is the widest of all prohibitions. No rider, no further disqualification, no concrete explanation is given, provided, and there is no mention of category of the things on which our trademark is to be is in use. No such cap has been attached. So in that case we get an idea that it is the widest of all, wherein one can easily invoke it in any of the matter, in whatsoever matter. The examiner may invoke section 9(2)(a) and can refuse the registration of a trademark. Why do I say so? Because no rider has been attached to it. There is no such sort of no explanation is given to it. Only idea that we have about its interpretation and its purport and its construction is through some of the judicial precedents, some of the judicial dictations, and if we see those dictas, we get a clear idea that this 9(2)(a) can be invoked in any of these situations if there is a likelihood of confusion, or if you see nature of the trademark is such which may lead to deception to the public. Friends, I would like to pause here and first of all would like to make it little more clear for my viewers by invoking few case studies wherein it has been clearly discussed as to what can cause a confusion and what can lead to deception. In Usha Rani versus Registrar of Trademarks, year 2004, friends, patent trademark cases 647, and it's decided by Intellectual Property Appellate Board. The word Usha in respect of switch gears was denied. Well, when we see the word Usha in Indian context, I am restricting my this statement only to the Indian context. We usually know Usha by Usha fans, by products which are electronic products, Usha sewing machines, which are very popular among the masses, even among the far-flung rural areas. You see, Usha sewing machines are very popular. So in this case study, friends, the infringer, you see, wants to use Usha as a trademark on switch gears, which are also electronic goods. But Usha trademark is owned by the plaintiff for so long, and it is a reputed trademark. Everyone knows that Usha sewing machines, or maximum segment of the public knows that Usha sewing machines, Usha fans do come from the source which is a manufacturer of Usha fans and Usha sewing machines. But in this case, friends, Usha in respect of switch gears was attempted to be registered as a trademark, and the same was denied by the registrar of trademarks because of one simple reason, that it may cause a confusion, it may lead to deception, because the masses and the society knows Usha in respect of fans, in respect of what we call it sewing machines, not in respect of switch gears, though in this case the goods are similar, I mean the same electronic goods or maybe sort of similar electronic goods. But the point is, the trademark examiner thought that if this Usha word is given a registration to another person, not to the manufacturers who are the parent and original manufacturers of Usha sewing machines and fans, then in that case Usha in respect of switch gears may lead to confusion, because you see in this case this was also discussed and deliberated that the trade channel of both the goods in question are similar. Moreover, the trade name, I mean the trademark to be used, to be registered is also similar, is rather identical. So if the identical trademark is given a registration, this Usha is to be given a trademark registration on switch gears, then people may, the buyer, the consumer, the end user may start thinking, because of this confusion, that these products which are switch gears in question or in context are also manufactured by original makers of Usha products, say for example Usha sewing machines and Usha fans. But that's not the case. The fact is that these are some other manufacturers coming up with a new venture of manufacturing switch gears, and their trade channels are similar. Their buyers, consumers are kind of aware about Usha, they know Usha since long. So the point is, it's a case where one can understand that an identical trademark and on similar goods was refused and denied because of what reason? Because that there is a prohibition covered and given under section 9(2)(a) which says that any mark, if it is of such a nature which leads to deception or can cause confusion, shall not be registered. We have another case study to understand it further. In this case study, friends, you see, Honda word was proposed to be used for pressure cookers and it was denied because Honda Motors Company, the manufacturer of Honda motorcycles, a very prominent Honda motorcycle maker in India, known everywhere that Honda motorcycles are being manufactured by Honda Motor Company. In this case, if you see, versus Charanjit Singh 2003 Delhi patent trademark cases, you see this Delhi High Court said that Honda for pressure cooker cannot be registered. The peculiar thing to be noticed and the important and relevant point to be noticed in this case law, friends, in this case study, you see, Honda was proposed to be used on pressure cookers, completely dissimilar goods from the goods of Honda Motor Company. The goods of Honda Motor Company are motorcycles and goods of this Charanjit Singh were pressure cookers. So these are dissimilar goods. Even in the case of dissimilar goods, section 9(2)(a) was invoked and it was found that Honda word, if given a trademark on pressure cookers, then it may lead to confusion. It may deceive public because public knows and the buyer knows that Honda is a very prominent manufacturer of motorcycles in India. So they may relate and associate that these products, which are pressure cookers in this context, are also the products made and manufactured by Honda Motor Company. So that is how you see this section, by purview of this wide language and open language, tries to curb the confusion to take place in whatsoever manner in the mind of the end consumer, in the mind of the public, in the mind of the buyer. Along with that, this section 9(2)(a) tries to cover, you see, another aspect and tries to protect another aspect, the interest of the trader. The trader, for example, you see in the case of Honda Motors Company, friends, Honda Motor Company people are well known. They have made their reputation over the years in their products. So the law does not allow anyone to take right of the image and reputation and goodwill of any prominent manufacturer by using their trademark, and that is how the law tries to strike a balance between the right of the trader as well as right of the buyer. Rather, I will say that the law tries to take care of the interest of the buyer as well as of the trader, as well as the rival traders. Well, friends, I will go back and will again come to section 9(2), and the very important aspect of 9(2), you see, it is a two-edged weapon, as deciphered and discussed and detailed by me, that this provision 9(2)(a) on the one hand protects the interest of the buyer by precluding him to get deceived, by precluding him to get cheated, by precluding him to get confused in the market, because the consumer that comes in the market, he or she does not carry a memory of Sherlock Holmes. They are very common people going to the marketplace, buying or thinking of buying goods and or availing services in the market. They usually don't know the intellectual property, the facets of intellectual property, the implications of intellectual property. They don't understand, they cannot distinguish between deceptively similar marks, confusingly similar marks. They are consumers of unwary recollection. They are consumers who are unwary consumers. They are consumers of imperfect recollection. They cannot recall the real product, the original product, original trademark, and a counterfeit available in the market. So their you see recollection, their capacity to distinguish, their knowledge of intellectual property, it's in doubt. I mean that is not of that level where one who knows IP, one who understands intellectual property, one who can make out the distinction between two products, two counterfeit goods and the original goods. So in comparison with the later person, the normal consumer in the market is of unwary mindset and of imperfect recollection. When he goes to market, the you see probability of him getting duped, probability of him getting cheated remains very high, because he does not know about the distinction between original trademark and the counterfeit trademark, or say the infringed trademark. So this section 9(2)(a) in its purview is a two-edged weapon which serves the consumer's interest as well as of the trader interest. When it comes to the trader interest, you see, it does not allow any later trader to get or own a trademark which is going to cause confusion, or a trademark which may lead to deception. And especially, why do I call that section 9(2)(a) is of huge implications? Because section 9(2)(a), friends, is not mentioning that it can be applied, or not streamlining that it has to be applied only in a case when a similar or identical trademark is to be used or proposed to be used on similar or dissimilar goods. It leaves the scope open for the examiner to invoke it, because it does not mention that the prohibition is to be invoked and will get invoked only when the similar goods or similar services are identical, or a similar trademark is used. In any of the case, in whatsoever of the case, it can be invoked, it can be always availed by the trademark examiner if he finds the deception and likelihood of confusion involved in the proposed trademark, then he can absolutely refuse the registration of that trademark. Another thing, you see, friends, when it comes to section 9(2), I find that it provides protection without determining goods or services, as mentioned and detailed and discussed by me. It does not mention the kinds of goods or services used. It just simply say that if anything is going to lead to the deception, is going to lead to the confusion, and if it is of such nature, only the preponderance of the nature is to be proved. There is no need to establish before the trademark registrar in concrete terms that this may gonna cause deception. The only thing that the complainant, that the you see wronged has to establish is the preponderance of likelihood of confusion to take place, deception to take place. If he or she succeeds into doing that, then they will be able to get invoked section 9(2)(a), and the trademark will be able to get invoked section 9(2)(a), and he can easily apply it. Well, friends, that's all about 9(2)(a). I'll be now, you see, jumping to 9(2)(b), and when it comes to 9(2)(b), well, friends, as we have already seen the language of 9(2)(b, in 9(2)(b) we have seen that there are two keywords noticeable used here, that any mark which is going to hurt the religious susceptibilities, or a mark which is going to harm the religious susceptibilities, shall not be registered. So what can be the possible outrages? I mean, what can be the possible marks gonna hurt the religious susceptibilities, and whose religious susceptibilities? In Indian context, the Indian society have so many religions in it, and you see, we have so many gods and goddesses, unlike other nations where either the Christianity is observed by and large, or Islam is observed by and large. We in India, you see, have many religions, a society of many gods and goddesses. So the question becomes little ticklish at this stage, and it becomes little complex at this stage when this invocation or the attempt to invoke section 9(2)(b) is deliberated, is pondered. I'll take up this in a very elaborate manner, friends. So the very first question that I would like to highlight and discuss: how much offensive when it comes to religious susceptibilities? What would gonna offend the sentiments, the religious susceptibilities of the people? And whose religious susceptibilities, whose sentiments? Are these the sentiments of the trademark examiner, the sentiments of the trademark office, the sentiments of the public at large? Whose sentiments are in question or have been made? You see, the bottom line we have to discuss. So what's the bottom line for determining the possibility of religious susceptibilities, or the possibility of religious harm to be caused to the sentiments of the people? So another question that we are going to take up: who is to be taken into consideration while determining it, while determining the religious susceptibilities? Single individual, many individuals, the society at large, the trademark examiner, the applicant, the rival of the applicant, or you see, there can be so many people, or say there can be so many things in this spectrum who can be kind of taken into the consideration. But the courts cannot decide in such a wide manner. They have to zero in, or they have to filter it down. So the point is how or in what manner the courts have zeroed it in, the courts have filtered it in, and summarized it in. That's the point to be understood by all my viewers when it comes to the invocation of 9(2)(b). And the third thing, the very possibility or likelihood of examiner's bias. These are the three pertinent, or the fourth one is what would remain: the impact of the goods and services with the use of some religious connotation, with the use of some religious pictorial representation, or any mark, or say any symbol which connotes some sort of religious linkage, which has got some sort of religious bearing. You see, what would be the impact of those goods? And moreover, what if the goods are, or goods in itself are of such nature that the name of the use with those goods are posing a tangible, hurting the susceptibilities, are posing a tangible danger of bearing to that religious susceptibilities? If we change the goods or services, in that case, there may be a case where you will find that it does not impact in that manner. So there are four pertinent points that I am going to discuss when it comes to religious susceptibility wala thing. The very first thing, as decided in some of the cases by the courts, how much offensive the mark should be, how much outrageous the mark should be. Why this question I'm considering, friends? It is quite clear and apparent that when we have to measure the potential of the very capacity of the mark to cause harm to the religious susceptibility, we have to see what is that mark, how much that mark is offensive, how much that mark is gonna harm or hurt the religious sentiments of the people. how much outrageous that mark is. So the courts in some of the cases in India have let down that, you see, if the mark is outrageous to the sentiments of accepted, or say sentiments of substantial segment of the society, substantial segment, in that case that mark can be called a mark hurting the religious susceptibilities, or can be called a mark causing, disturbing the religious susceptibilities, and it shall not be registered as per 9(2)(b). So that the test let down by the courts in some of the judicial precedents is the test of seeing the mark's impugned or obnoxious nature into the mind or into the understanding of this substantial segment of the society. If the substantial segment of the society finds and terms that mark as the mark causing religious bearing, as the mark causing some sort of distortion in the sentiments or some sort of harm to the religious sentiments, it shall not be registered. So the test has to be taken care of by the trademark examiner or the trademark board at the time of invoking this section 9(2)(b), at the time of scrutinizing the trademark application on the grounds of prohibitions covered under section 9(2)(b). He or she needs to see that this mark is outrageous enough, is offensive enough to cause harm to the religious sentiments of the people. And when he or she, the trademark board, I mean the examiner, when sees it, when watches it, then he applies the test of substantial segment of the society. Well friends, I rest here. Thank you so very much. Welcome friends. We are discussing the nuances of section 9(2)(b) and some of the key points of section 9(2)(b) under Trademarks Act 1999. Well friends, we have seen that when invoking section 9(2)(b), one has to see how much outrageous that mark can be. One has to see how much offensive that mark is. The third thing that I would like to cover in this session is about the probability of examiner's bias while invoking section 9(2)(b). Well friends, the probability of examiner's bias under section 9(2)(b) remains very high, because sometimes the examiner likes or say follows one religion. It may be a case, I mean just hypothetically I am imagining and examining that if the examiner is follower of one religion, then he may not like any mark of his religion or any pictorial representation of his or her god to be used as a trademark. There may be a case where he may be a very fanatic person when you see being that official, he may be very fanatic and may like the mark of another religion to be used for obnoxious goods. So that examiner bias or the probability of examiner bias remains very high. That has to be checked, and for that I believe there can never be a concrete solution. There can be no concrete answer. So in that case, what has to be done? What can be done? The only thing that is possible to be done to restrict and to kind of guide the examiner in scrutinizing the application on the point of section 9(2)(b) is to say them and to tell him that he needs to be very objective in his understanding. He cannot afford to be too subjective, and he should not be too subjective. He has to be very objective. He has to have some sort of professional commitment to examine and scrutinize the application without any sort of bias towards one or the another religion, and that is how it can be avoided. Otherwise, there in the law no solution has been provided. This is one of the probability that I can see and I see which may occur, which may happen. The last thing that I am going to cover when it comes to religious susceptibility, friend, it's about the goods in question. It's about the goods and services which are used, or say goods or services on which the mark having some religious bearing, having some religious connotation is used. They make a real difference. The goods or services, the nature of goods or services, they make a real difference. Why do I say so? Well, friends, if the goods are of obnoxious nature, if the goods are such which are unacceptable, if the services are such which are unacceptable, in that case, if the mark having some religious bearing is used, if the mark having some religious connotation is used, then nobody would accept it. Then no substantial segment of the society will gonna accept it. It has to be outrightly rejected, absolutely rejected. But there may be a contrary case where the religious connotation in the form of a mark or a mark having a religious bearing is used on the goods which are acceptable to the substantial segment in the society as the goods, which those services are acceptable to the society as the services in the market. In that case, the notion, the perception of the society may not outrightly gonna reject the religious connotation or the mark having a religious bearing. So it varies, I mean, from goods to goods, or say from services to services, the likelihood of variation is there. In one context, the same mark may be outrightly outrageous. In another context, in the case of another kinds of goods, the same mark may not be that outrageous, that offensive. So that examiner has to take into consideration the acceptability of that mark to the substantial segment of the society. If the substantial segment of the society accepts it, enjoys it, does not outrightly reject it, does not posit any sort of likelihood of harm to the religious sentiments, then it's fine. Well, friends, to my understanding, that's all about religious susceptibilities. I recall one case law where the word Ramayana was proposed to be used, and it was denied by the trademark registrar to be used, because Ramayana as such in Hindu mythology has been a religious text, has been a religious story of Lord Rama. So that's why you see it was outrightly rejected to be used on some goods. Similarly, you see in many other jurisdictions apart from India, I have seen that many marks are not allowed to be used as trademarks because they possess some sort of religious bearing. some sort of religious connotation. That's all about this 9(2)(b). Let us move to 9(2)(c). 9(2)(c) says and covers two things which are very prominent things. You see, any mark which is scandalous or obscene in nature shall not be registered. Well, friends, the question comes to my mind, what can be so scandalous, what can be so obscene? Well, there can be so many things, and those so many things in the form of a mark, in the form of a symbol, logo, device, in the form of word, letter, numeral, may be termed as scandalous or obscene in nature and may not be given registration of a trademark. You see, it can be a word, it can be a pictorial representation, it can be a art, it can be a symbol, it can be a logo, it can be a device which may be termed and can be termed as scandalous or obscene. Well, what is obscene varies from person to person, from society to society. It's kind of a moral thing, or say determined on the principle of morality. So anything which is likely to offend accepted principles of morality, anything which is likely to offend the accepted principles of morality can be termed as scandalous or obscene. So any mark which is in contravention of accepted principles of moralities cannot be given or shall not be given a trademark registration as per 9(2)(b). But again, the question that arises into my mind and must arise into your mind as well is the question of determining the accepted principles of morality. Who determines the accepted principles of morality? And will those accepted principles of morality will remain same for the entire society at large, or will they vary from society to society? It's a very confusing state, or say very dilemmatic state, where one cannot determine the accepted principles of morality. But the accepted principles of morality by and large, you see, similar. The family values, the social values are sort of similar to an extent in Indian society. So in Indian context, I can say that the trademark examiner, while scrutinizing the application at the pre-registration stage, has to have look at the accepted principles of morality. He has to see, analyze and gauge the proposed mark to be registered on this parameter. And when he finds that this mark proposed to be used as a trademark may pose a tangible danger to be called scandalous, or may be termed as obscene, it shall not be registered. If it cause outrage, you see, if it can cause outrage, then it shall not be registered. If it undermines the family and social values, etc., it shall not be registered. There are several examples in Indian context which can be taken as a case study or as examples to understand this prohibition. One example that comes to my mind is the use of the proposed use of a picture or a pictorial representation of a liquor bottle. The shape of a liquor bottle, not a pictorial representation, I'm sorry. It's the shape of a liquor bottle. The shape itself was obscene. It was found to be scandalous. That's why it was refused. It was not given as a trademark. Similarly, a name of one very prominent automobile car, which was found to be obnoxious, was not given trademark registration, was denied the trademark registration on the ground of 9(2)(b). So these 2-3 examples which I feel I don't need to explain are the pertinent examples to be quoted and given when it comes to 9(2)(b). Let us see the last aspect, friends, the 9(2)(d), which I told is quite simple relatively in comparison with the preceding three prohibitions of section 9(2). This prohibition is a prohibition under the Emblems and Names Act. Well, friends, the case study that is mentioned on your screen is Sable-Wagner versus Union of India. In this case study, friends, word Chhatrapati Shivaji was proposed to be used on BD packaging, was proposed to be used as a trademark on BD packaging, on a cigarette. You can the listeners, non-Indian listeners does not understand what BD is, so for them, for their convenience, I would like to tell that a kind of cigarette indigenously made or say very cheap kind of smoking thing is BD. So the Chhatrapati Shivaji was proposed to be used on BD. In this case law, it was found that the word Chhatrapati Shivaji, the name Chhatrapati Shivaji, cannot be used as a trademark on any goods because it is prevented to be used under the Emblems and Names Act. Similarly, in one of the case, word president was proposed to be used as a trademark, and it was found that president is prevented to be used under the Emblems and Names Act. So it cannot be registered, it shall not be registered as per the prohibition given under 9(2)(d). Well, friends, I believe this prohibition given under 9(2)(d) is rarely invoked because the occasion rarely takes place, rarely happens. To conclude this section 9(2) and the prohibitions covered under section 9(2), I find and I again say that section 9(2) is widely worded and it covers so many prohibitions in its purport and its purview, but the very first subsection of section 9(2), 9(2)(a), the widest of all prohibitions, not only of the prohibitions covered under section 9, rather the prohibitions covered under section 11(2), because it has got no rider, it has got no restriction, it can be invoked in any of these situations. The one very prominent case law that I am reminded of to explain you this 9(2)(a) prohibition in the form of causing deception or confusion is the case of Sundar Paramanand Lalwani versus Caltex India Limited. Sundar Paramanand Lalwani versus Caltex India Limited, and it's a Bombay High Court decision of year 1969, friends. The fact sheet of this case law is quite simple to comprehend and discern. You see, in this case law, the word Caltex was in question or was under the scanner of the court. The word Caltex, you see, was proposed to be used by the present appellant Sundar Paramanand Lalwani on watches. He had a business of importing certain watches from abroad, and he had a business of selling those watches in India. He named those watches as Caltex watches, where the fact is that in India at that point of a time, Caltex India Limited had a very huge business of petroleum and petroleum goods with the word Caltex. I mean, it's a case of use of identical trademark, Caltex for petroleum goods and Caltex for, you see, watches. The goods are dissimilar, the trademark is identical. Well, friends, you see, the prohibition of section 9(2)(a) under this, in this case law, can be easily invoked because, you see, Caltex on petroleum goods was in long use, and at that point of a time, almost everybody used to know Caltex as a Caltex trademark for petroleum goods, and the appellant started using it on watches which are dissimilar goods. There is no straight prohibition on the use of identical trademark for dissimilar goods. One can use it, but at two occasions under the trademark law, this use has been checked. One is the situation of section 11, where you see the identical trademark cannot be used on dissimilar goods if the earlier trademark is very well known trademark, is a trademark of reputation, is of repute. You see, on terms of section 11 or on the prohibitions provided under section 11, which we have not studied yet, but you see, I am giving you a general idea that on the terms and on the prohibitions provided under section 11, the use of word Caltex on watches, given the fact that Caltex on petroleum products was well known in India, cannot be done. One cannot use it as per section 11. Another occasion where use of a similar or identical trademark on dissimilar goods is checked is the occasion of section 9(2)(a), which reads clearly and explicitly that if any mark is of such nature as to cause deception or cause confusion, shall not be registered. So in that case law, friends, in the case law of Sundar Lalwani Permanent versus Caltex India Limited, the court found that the consumers, the buyers in the marketplace are buyers of unwary mindset. They are people who are people of imperfect recollection. They don't know whether the word Caltex is just used by another manufacturer for the manufacturing of watches. They will always find it as if, or will always perceive it as if, the Caltex who manufactures or deals in the petroleum goods is the manufacturer of these watches too, and they may start associating those goods with the goods of the earlier manufacturer of the Caltex India Limited. On the front of section 11 or on the parameters of section 11, it can be any time negated, it can be any time rejected by invoking relative grounds. But I am talking about section 9(2)(a), where at the pre-registration stage, the trademark board has to scrutinize the application, and they can invoke this 9(2)(a), which says that if any mark is of such nature which is going to deceive or cause confusion. So this mark may gonna deceive or cause confusion because the marketplace consumer is of imperfect recollection. He does not know much about the trademark thing, he does not know much about intellectual property, he cannot distinguish those two products. He may get duped and cheated and deceived, thinking that these goods are also the goods manufactured by Caltex India Limited. The watches are also the watches coming from the source of Caltex India Limited. As Caltex India Limited has made its mark in the market and they are known to a substantial segment of the society. So the confusion thing, or say the deception possibility, remains very high. That's why in this case law it was found that Caltex on watches should not be allowed to be used as a trademark, and it was rejected, and the appellant's plea was dealt with a negative answer, was not given a trademark registration. Well, that's all about section 9(2), friends. In the next session I'll deal with 9(3), which is more interesting in comparison with the earlier two prohibitions covered under 9(1) and 9(2). Thank you very much. See you next time.
Thank you, sir. Thank you so very much. And dear friends, we would be meeting again very soon. Till then, take care. Goodbye. Thank you, sir.